Good evening, ladies and gentlemen. Welcome to the September 26th Zoning Board of Adjustment meeting for the town of Merrimack. If you would all please rise for the Pledge of Allegiance.
Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Rich, if you would read the preamble, please.
Absolutely. Good evening, ladies and gentlemen. We will proceed with the petitions in the order they are listed on the agenda unless the board deems it appropriate to take a petition out of order. State law and local ordinances set out the criteria that must be met in order for this board to grant a request. The minimum requirements are outlined on the form provided by the Community Development Office, and the petitioner should proceed with this format to provide adequate justification for the board to grant the request. The chair will then open the meeting to hear testimony either for or against the request. All discussion will be between the speaker and the board. Please be respectful of all, and in the interest of time, refrain from repeating previous testimony. No new documentation will be accepted by the board for consideration this evening, but the board reserves the right to ask for additional testimony at any time. After hearing the facts from all parties regarding a petition, the chairman will close the public hearing, and the board will deliberate and vote on the request before moving to the next petition. Please turn off all cell phones and pagers if you have them.
Thank you very much. For anybody that will be speaking this evening, you need to be sworn in, so if you could please stand and raise your right hand. You're going to be doing any speaking tonight for or against a petition. All right, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God? Thank you very much. The next ZBA meeting will be Halloween, October 31st, 2018. Just a reminder, when you come down, there is a clipboard. Please make sure that you sign in. Make sure that the light is bright green. I know the little indicator is green as well, but make sure it's bright green. And please make sure you also state your name for the record. Thank you. The first petition is Cross America Partners LP petitioner and Limits. Okay, I'll do that. Limits Petroleum Inc. owner, variance under section 2.02.2b of the zoning ordinance to permit the use of an existing gasoline service station that has been closed for more than a year, causing its legal non-conforming status to lapse. The parcel is located at 605 Daniel Webster Highway in the C1 Limited Commercial and Aquifer Conservation Districts and Wellhead Protection Area, tax map 6E-1, lot 055, case number 2018-26. As Fran is not in here this evening, Rod, you'll be sitting, going in for Fran tonight. Okay? Thank you. State your name and kind of give us a quick overview of what we're looking at here.
Thank you.
Can you make sure you're bright light?
All set? Better?
I think so.
All right.
Yeah. All right.
My name's Brett Allard with Bernstein Schur, here tonight on behalf of the applicants, Cross America Partners. They are the hopeful tenants of the formerly BP gas station at 605 Daniel Webster Highway. Here with me in the back is Joel Dupree. He's with Cross America Partners as well. The property is located in the C1 zone. As you said, it's about half an acre, formerly the BP gas station. It was constructed in the early 70s, and at the time of construction, it was permitted by right in the area. At that time, there was no C1 or C2 limited. It was just a general commercial zone, and gas stations were commercial use that were permitted by right. So Cross America just wants to reopen it. They do require the variance now because it hasn't been operational for a year. There was a previous variance granted in the late 90s for the canopy. It encroaches into the front setback by about 1.5 feet. That's still there, so that variance is vested. But that's a little bit of the zoning history on it. And we're just looking to get a variance tonight to reopen the gas station. And the first thing that I wanted to address before we get into the 5 variance criteria is that it's actually very possible that a variance might not be needed tonight. because the non-conforming status might not be lost. And if you look at the case of Pike Industries, Inc. versus Woodward, in that case, Pike Industries was utilizing an asphalt operation that was a non-conforming use. And the ordinance said, very similar to what the Merrimack's ordinance says here, quote, if a nonconforming use has been discontinued for more than 1 year for any reason, such nonconforming use shall not thereafter be established. Well, Pike stopped producing asphalt for over a year, but the court actually held that, quote, but Pike maintained the asphalt plant in a state of readiness to produce asphalt, although it had no customers with orders suitable for the plant. Therefore, although Pike did not produce asphalt in 2006, it continued to use the asphalt plant, and its non-conforming use status was not lost. So here we have the gas station, which is still there. The tanks are in the ground. The infrastructure's there. It's in a state of readiness, but until now, the owner didn't have a tenant that was suitable to resume operations. And we're not asking that the board, say that we don't need to go through the variance criteria. It's just something that we would ask you to consider when we're going through the merits.
Appreciate the update. If we want to get into the 5 criteria and just stop after each one in case there's any questions.
Sure.
Thank you.
So first, the variance would not be contrary to the public interest, and the courts have held that any variance will in some measure be contrary to the ordinance. But to be contrary to the public interest, the variance must unduly conflict with the ordinance such that it violates basic zoning objectives. Here, one of the most important things the courts look at is whether the proposal will negatively alter the character of the neighborhood. And here we're not going to have any alterations because, as I said, all the tanks are there, the infrastructure's there, the buildings are there. If anything, resuming operations from a vacant state will improve the aesthetics of the site, and it's the intent of the tenant to restore the property to its former condition, which, on a public interest level, decreases the threat of crime and vandalism and other sort of negative impacts that can be associated with vacant buildings in general, and including gas stations.
Any questions? All right, number 2, please.
Granting the variance would be consistent with the spirit of the ordinance, and the courts have held that this is closely related to the first prong, that they won't be contrary to the public interest. So I would rely on those reasons I just stated, but in addition, granting the variance wouldn't threaten the health, public health, safety, or welfare. The property complies with all pertinent dimensional zoning regulations, or has the existing approval for the canopy on the 1.5-foot encroachment, and the granting the variance would enable a reasonable use of the property.
Questions? Number 3, please.
Substantial justice would be done by granting the variance, and the courts have held that there's substantial justice done when there's no harm to the public that outweighs the benefit to the applicant. And here there would be a significant loss to the applicant, any future owner of the property, if the variance was denied, because that decision would essentially mean that either the property has to remain in its vacant condition, or all the infrastructure needs to be torn down and the fuel tanks need to be dug up. So we would say that there isn't any gain to the public by requiring that, and there would be a loss to both the owner and the public if the variance was denied, because the applicant intends to revitalize the property from a vacant to operational condition.
Questions? Okay.
The values of surrounding properties will not be diminished. If anything, vacant gas stations would diminish surrounding property values. They can fall into disrepair, eyesores. They can attract crime and invader and other sorts of things like that. For an example, I would point the board to the vacant station on the southern end of Daniel Webster Highway next to Raisin's Landscaping. That's the sort of situation that we're trying to avoid. And if anything, the revitalization of the station here will have a positive impact on surrounding property values, and they will be properly maintained so that it's not an eyesore.
Questions? Okay. Number 5.
Literal enforcement of the ordinance would result in unnecessary hardship. So as this board knows, the first thing you look at is the special conditions that distinguish the property from other properties in the area. In the immediate area, this is the only gas station, although as you go up and down Daniel Webster Highway, obviously there are some other ones, but in the immediate area, this is the only gas station, and pretty unique, I think, is it's probably the only closed gas station that requires a variance to reopen. That's a pretty unique feature. And the existing features and conditions of the property as far as improvements go, with the tanks and the canopy and the store and everything else that's there, really make the only practical use of this property a gas station.
And proposed use is reasonable?
It is a commercial use in a C1 zone. The gas stations aren't specifically permitted in this area, but it's not as if, the applicant's intending to drop this thing in the middle of a residential neighborhood or anything. It's along Daniel Webster Highway. Just wants to resume the operational use that was legal again when the station was first constructed.
Okay, thank you. Does everybody on the board feel hardship has been discussed and covered? Okay, excellent. No reason to go further. Any questions from the board to the applicant regarding this proposal? Okay. If there's no further comments, I'm going to open this up to the public. Is there anybody that'd like to speak in favor of this petition? Is there anybody that'd like to speak against this petition? Well, if you want to speak for or against it?
I live right across the street. That would be so convenient.
If you'd like to come down, you can put in there. All right. Well, sure, have a seat. Come on in, sign in, state your name, and, yeah.
Sorry, I have a long name.
That's good.
I can go.
You can, by all means.
My name is Kinsley Osgood Barnard. I actually live in 9 Harris Ave, that big Victorian that's been vacant forever. And I personally think that it would be an asset. I don't speak for anybody else in my neighborhood because I'm new. They don't really know me yet. But as somebody not having a close gas station, it would be convenient to just be able to leave home, fill up for gas, or come home, fill up for gas. And again, it is an eyesore, crime, those things. I hate seeing vacant things there, and I would like it to not make my property value go down.
Okay.
So,
Excellent. Well, thank you.
Thank you.
very much. Thank you. Anybody else like to speak in favor? And nobody against? All right, you can come back down if you'd like. If there's no one else that would like to speak, I'm going to close the public hearing. Discussions, motions from the board.
Motion? I'd like to make a motion to grant Cross America Partners LP petitioner and Lee Mills Petroleum Incorporated variance under section 2.02.2.b of the zoning ordinance to permit the reuse of an existing gasoline service station that has been closed for more than 1 year, causing its legal nonconforming status to lapse. The parcel is located at 605 Daniel Webster Highway in the C1 Limited Commercial and Aquifer Conservation Districts and Wellhead Protection Area, tax map 6E-1, lot 055, case 2018-26.
Do I have a second? Do I have a second? Okay, Kathleen seconds. Any other discussion items, questions before I vote? Okay, excellent. All in favor of approving the petition, say aye. Aye. All opposed? Abstain? 500.
Thank you very much.
Thank you. Have a great night.
You too.
All right, one down. All right, next is, please come on down, Rachel Shellhorn. I think I said that correctly. Applicant owner, variance under section 3.05 of the zoning ordinance to permit an attached 20 by 24 garage addition 20 by 24 garage addition, 8 feet from the property line, whereas 30 feet is required. Parcel is located at 23 Ingham Road in the R4 Residential and Aquifer Conservation Districts and Wellhead Protection Area, tax map 3C, lot 026, case number 2018-17. Do you need a recusal? Okay, Kathleen will be recusing herself, so she will be stepping down. Lenny, you're on. Lenny, you're going to be sitting in for Kathleen. She's recusing herself on this one. Thank you. Rachel? Hi.
Yes, hi. Rachel Shellhorn, 23 Ingham Road. I just purchased a property in March, so I'm excited to be a new resident of Merrimack.
Excellent. Why don't you give us kind of a quick overview of what you're looking to do here?
Sure. So buying the property, I knew that adding in a garage was kind of big on my priority list, and the garage that's currently existing is, as we'll get into, not very functional, and it's not attached, and it's very much an eyesore. So adding the attached garage that's proposed is just gonna help, make it safer and increase the property values around the neighborhood. So I'm really excited about it.
All right, so I'm looking at the picture here. Is there any questions before we have her go into the 5 points? Okay. All right, so you had the 5 points of law that you had to complete for town.
I do.
If you could stop after each one as you read them into the record.
Sure.
If we have any questions, and then we'll just go from there, starting with number 1.
Number 1 is granting the variance would not be contrary to the public interest. The proposed garage would be safe to park cars. Due to the proximity to the road, the existing garage is unsafe, deeming it impossible to house cars. The proposed garage will enhance the neighborhood, increase property value, and will impose no burden to abutters.
Any questions on number 1? Number 2.
The spirit of the ordinance is observed because the current out-of-date, non-conforming, and unsafe existing garage will be removed and replaced. The new structure will comply with the front setback from Cambridge Street and will be moved 8 more feet back from Ingham Road. The proposed garage will not only be more aesthetically pleasing, but the property will feel more private and residential.
You said it's non-conforming. The garage is there right now is non-conforming?
Correct.
Okay.
If you look at the
I see.
pictures, the actual drawings, you can see that the front of the existing garage is pretty much right at the property line.
Yep.
It's not set back really at all onto the property. The front of the garage is right at the property line existing. So the new garage will be pushed back 8 feet from the front of Ingham Road, and the new garage will also be in compliance with the front setback on Cambridge Street as well. The existing detached garage is out of compliance on both sides.
And this is a 2-car garage?
The existing garage is.
No, the new one.
The new one will
Yeah,
be,
the
yes.
existing, yeah, that's a really small cars. Yeah, okay. All right, number 2, please.
We did number 2?
How about 3?
Oh, number 3, yeah.
Number 3, okay. Granting the variance would do substantial justice because the proposed garage will be much more functional. Not only will the attached garage allow parking cars inside, enough room will exist to park cars off the road in front of the new structure. The proposed garage will enhance the desired residential feel, more closely resembling the other houses in the neighborhood.
Questions? Number 4?
Number 4, for the following reasons, the values of the surrounding properties will not be diminished. Removing the existing unusable, unsafe eyesore of a garage and adding a brand-new attached 2-car garage will not only add value to this property, but to the surrounding properties, the surrounding properties and neighborhood as well.
Next.
Unnecessary hardship. So owning the special conditions of the property that distinguish it from other properties in the area, denial of the variance would result in an unnecessary hardship because no fair and substantial relationship exists between the general public purpose of the ordinance provision and the specific application of that provision to the property because the property is currently a legal, non-conforming lot. For that reason, it makes it impossible to add a new garage without infringing on the required setbacks. Additionally, the property sits on only a .23 acre lot, adding to the unnecessary hardship of building the garage within the current legal setbacks.
And the second part of that?
The proposed use is a reasonable one because approval of the variance will grant the ability to replace an existing non-conforming structure with is both unusable and unsafe. Allowing this addition will increase safety, property value, neighborhood aesthetics, and make the property more functional.
Does anybody feel that, no, that's covered? Okay. Any other questions from the applicant from the board? Okay. I'm going to open up open this up to the public. Does anybody like to speak against this petition? Does anybody like to speak for this petition? Okay, we'll close the public. I'm in looking at this is, we see this all the time. We have a bunch of these non-conforming lots all over Merrimack. And this is just a situation which You know, it would make everything look a lot better, I think.
She wants to make it less non-conforming.
Yeah, but, you know, as much as you can with that.
Exactly.
Yeah. So, that being said, any further discussion from the board? Motions?
I motion to accept.
Turn your mic on.
Variance.
Turn your mic on.
Grant.
Or put it down. There you go.
I motion to grant acceptance of the variance under section 3.05 of the zoning ordinance to permit an attached 20 by 20 foot, 24-foot garage addition 8 feet from the front property line, whereas 30 feet is required. The parcel is located at 23 Ingham Road in the R4 Residential and Aquifer Conservation Districts and Wellhead Protection Area. Tax map 3C, lot 026, case number 2018-27.
Second.
I get a seconded from Rich. No further discussion. We'll do a vote. All in favor, say aye. Aye. All opposed? That would be 5-0-0. Congratulations.
Thank you.
You're welcome.
Have
Just
fun.
keep in mind that you have a 30-day grace period. If you build within the 30 days, someone can appeal it. But
Okay.
after that, so don't build unless you're ready.
Thank you.
Thanks. Should have said don't build until, that was what I meant to say. She figured it out. All right, next up. Kinsley Osgood Barnard. Barnard.
Sorry.
Applicant, owner, special exception under section 2.02.2.c of the zoning ordinance to permit the use of an existing single-family dwelling to continue on commercially zoned parcel that is being proposed for commercial use. The parcel is located at 9 Harrison Ave in the C1 Limited Commercial and Aquifer Conservation Districts and Wellhead Protection Area, tax map 6D-1, lot 038, case number 2018-28. Why don't you kind of give us what are we looking at here?
Do you need me to state my name again, or are you good?
You can state your name.
All
again.
right,
Yeah.
Kinsley Osgood Barnard. I am looking to, I don't know which, I have two of them here, so I'm,
We're gonna go with the first one, which is for section 2.02.2C. And we're gonna take them one at a time.
okay, which
Right.
one is that?
The first one, the special exception, the zoning ordinance to permit the use of an existing single-family dwelling.
Oh, okay.
Continue to live there.
Yes,
Sorry.
yes.
Okay, I'm looking to basically live there as well as work there as well. So it is a C1 property, but I'm looking to reside there as well as also operate a business there.
What's the business?
I'm boarding and grooming for dogs.
Okay, all right. You have neighbors?
I do.
How do they feel about it?
Right there.
All right, all right, well, we may hear from them.
Do you own the property?
Yes.
Okay. So, special exception, all right. And then the next one is the four-season porch. That's for the porch, okay. So why don't you have was it the four parts under the special exception? Can you read those in, please?
For the first one, right?
Yeah. Specific site, it starts with the specific site is appropriate location for such use or uses.
It's a C1 locate, this is for me to live there or for me to run the, live there?
Live there.
I mean, it's C1, I'm not sure, it used to be a residential, it's always been residential, someone's lived there.
Mm-hmm.
And not run I don't know if they ran a business, it looks like they did, but I don't think they legally did.
Mm-hmm.
So, I mean, I don't know what else to say, I don't see why
That's it.
not we could live
No,
there.
no, I'm just you, what you basically for.
Right, wait,
community development.
C1, yeah, it permits it, so, I mean,
All right. Any questions on that?
no.
No, okay. I was asking them.
Oh, okay, sorry.
That's
I'm new at this.
That's fine. No worries. No worries. We got another one to go through after this one. The next one, B.
Sorry, I can't read
The
my
use
writing.
is developed. We'll starting with that one.
I don't think I have the right one. This is for the house, right?
Yes.
Okay. There are already businesses very close to this neighborhood, as well as highway noise on both ends of the street. Kennel will be small, no more than 10 dogs at a time for boarding, 2 dogs a day for grooming.
Okay. Questions?
I'm just trying to clarify, so, I understand what you stated.
Right.
What I'm trying to understand, and maybe I should be asking Rob this, should these 4 criteria be regarding living there or
Right,
using
yeah,
as a
see, I
home
think I wrote it
occupation?
wrong.
Yeah, so basically what this is the residence already exists and has existed for many, many, many years. Because she is trying to establish a business, which is her right because it is in the residential zone, and she wants to maintain the use of the house as the residence while also running the business, it becomes a mixed-use property, so that's why the special exception is here. It's to allow the residence to continue to be used as a residence while also serving a business. So primarily, the special exception is to allow the residential use to continue on the property.
Okay, that's what I thought, I just wanted to make sure. Thank you.
Any questions on B? Is there, so for boarding, is there, I mean, do you have space for 10? I mean,
I have to build it. That's what the other special exception is for.
okay, that's, we haven't gotten to that, okay.
Yes.
All right, C, there will be no nuisance or serious hazard to vehicles or pedestrians because,
Well, after I wrote this, I found out that there is no, it's gonna be attached to the house, so there is no setbacks or anything, but it's gonna be far back from the street, more than 40 feet. I mean, I think it's like 100 feet or something like that.
okay. All right. And that's the barn you were talking about? That's
Yes,
the next
there's
one.
no, yeah, and we have 2 separate driveways, and they both fit, one fits 1 car, but the other one fits like 4 or 5 cars, so there wouldn't be any on-street parking or anything like that, and it's a dead end, so wouldn't be a lot of vehicular traffic.
Are you gonna have how, you gonna have parking for your customers coming in? and
Yeah,
out,
they
or-
come in, they drop off, they leave, they don't stay.
Yeah, okay.
So, but there's enough room to have, multiple cars come in, park, and leave, but I usually have them different times a day, they don't all come in at once.
Mm-hmm.
It's only little me.
Okay. Adequate and appropriate facilities will be provided for the proper operation of the proposed use or uses because,
We're actually building the facility, it's been designed. I don't have it with me, but I didn't have it with me that day either, they said I didn't need to have that, but we do have a design if anybody needs further of what it's gonna look like, and the kennels and everything broken up in the space.
okay. Rob, does this would need to go to planning after this?
Yes, absolutely.
Are there questions from the board on this?
How many kennels are you planning on having?
10. No,
Outside?
Inside,
Inside?
yes.
Okay.
And an outdoor run, they wouldn't be outside on their own.
Okay.
How big a run?
I don't actually have the dimensions of that off the top of my head. The barn is 20 by 30, so it'd definitely be 30 wide. I don't know how long my property line is, but basically my yard fenced in.
Okay, it's a planning question anyway, so
Okay.
no problem.
Any other questions regarding this special exception? All right. And let's open this up to the public. Is there anybody that would like to speak for this petition? Is there anybody that'd like to speak against this petition? Why don't you come on down? Kinsley, if you could just have a seat over there, please. Sir, if you could just sign in and then state your name for the record, please.
Yeah, my name is Andrew Moore, and I live at 11 Harris Ave. I am the neighbor.
Okay.
And my brother owned this house years and years ago, and
Oh, and Aaron,
Pull
Can
the
you-
mic closer to you,
Yes,
it's not
yeah.
picking up.
testing, 1,
yeah,
2.
there you go, yeah, there you go, there you go. Thank you. So you were saying?
And it has been sold a couple of times since then, and we were thrilled when it was sold and we found out that they were going to be improving the house and fixing it up, and these are our new neighbors. And they had told us that they were going to have a dog grooming and whatever here. I really don't object to that, other than I'm concerned about noise, if there's a bunch of dogs out there. But our house is quite far away, so it shouldn't be a big issue. And the other thing is, what probably comes up as far as the planning board is what this barn is gonna look like. But,
So just not to interrupt you, as far as the aesthetics and the barn and the look, that is planning. We look
That's-
at more
yeah.
of, can it actually be built there? But
Okay.
please continue.
so you're mainly looking at whether or not I object or go with
Well-
this whole plan of.
I didn't mean to interrupt what you were saying. It just, there's a fine line between what the zoning board looks at and what the planning board looks at. The planning board is gonna look at the final, like, you know, can this be built? Is it gonna be for the neighborhood? They take care of that, and Lynn can speak to that.
And noise and all of that
Okay,
come before
alright.
planning.
But the zoning, we look at the, you know, the lot size, the reasonable use, and how it would fit in with the neighborhood, the setbacks, things of that neighborhood.
Again, it's a business, it's their livelihood, and I don't wanna hinder anything that they have planned. I'm just concerned about our property values and the aesthetics of what's gonna be going in there. And, I mean, I'm a former builder, and I've been in this room before. I never came in without a set of plans. There's no reason to come in. But, that being said, again, I don't object to them doing this. I'm just concerned about the aesthetics and possible noise.
The possible noise, okay. I can tell you that, if things are approved tonight, next step would be go to planning, and you'll obviously be, you'll be able to, you'll get a notice on that, and be able to probably get a better idea of what it's going to look like, but, yeah, that would be the next step, but, you know, it definitely is noted, your
Okay.
concerns, from my
Okay.
perspective.
Thank you.
Were there any questions for him before he stepped on? Okay. Is there anybody else that'd like to speak for or against this petition? Kinsley, you can go back up. Okay. I'm gonna close the public hearing. Discussion on this, on the special exception, for this property. Concerns, questions, thoughts? And if there is gonna be a motion, there is a staff recommendation.
Yeah, so seeing as though this is going to go to the planning board to address things such as noise, parking, et cetera, I think from a zoning perspective, this makes a lot of sense.
I gotta be honest, you know, being able to use the space, especially utilize space and not have to build new space is something I'd definitely like to see get reused in Merrimack, so, I like the fact that, it's gonna be a mixed-use property. And there's actually, to be honest with you, there is anyone's in Merrimack, no, there's a similar property, similar, you know, dog facility that's, you know, about a mile down the road, so, or less than a mile down the road, so, you know, similar type situation, the owners of that facility actually live there, and so,
It's also a special exception, so that means it's already conforming.
Yeah.
So we're not dealing with a non-conforming issue.
questions?
I'd like to make the motion to grant Kinsley Osgood Barnard special exception under section 2.02.2.c of the zoning ordinance to permit the use of an existing single-family dwelling to continue on a commercially zoned parcel that is also being proposed for commercial use. The parcel is located at 9 Harris Avenue in the C1 Limited Commercial and Aquifer Conservation Districts and Wellhead Protection Area. Tax map 6D-1, Lot 038, case 2018-28, and that includes the staff recommendation that the applicant shall obtain a site plan approval from the planning board for the proposed uses on the site.
I'll second.
Second, all right, is seconded by Lynn. All in favor, say aye.
Aye.
All opposed? 500. One down, one to go. All right, next petition is Kinsley Osgood Barnard, right? Got that, good. Applicant owner, special exception under section 3.09 of the zoning ordinance to permit a 20 by 30 barn and four-season porch addition to a single-family constructed before June 29th, 1953. The parcel is located at 9 Harris Ave in the C1 Limited Commercial and Aquifer Conservation Districts and Tax Map Protection Area, Tax Map 6D-1, Lot 038, case number 2018-29. I will echo the sentiment, before you get into it, Kinsley, I will echo the sentiment of, the gentleman who spoke. I would like to see what we're looking at here, if we're gonna be approving a 20 by 30 barn and a 4-season porch, as far as plans. I don't know if community development has seen it, or if they,
We have not, however, in this circumstance, because the structure was built when it was built, and the zoning ordinance section that she's seeking relief from allows for additions and alterations that do not basically have setbacks due to the age of the property. The plan wasn't necessarily required, but it is certainly within the board's right to ask for that plan before they make a decision.
I mean, it's, I kind of agree with what was stated by the gentleman earlier, that, and I understand they may have not said it's required, but, when we approve plans for properties, generally seeing what we're looking at to kind of get an idea.
Right.
Understand that there's some non-conforming as well. If you'd like to speak, come on up.
I'm sorry, I'm Kinsey's mother, and I have been dealing with Dream Barns.
All right, why don't you come up and sign in, and, no, you can stay there.
All
She
right.
can just give her the mic. Did you swear in?
No, no, I did not.
Raise your right hand. Swear to tell the truth, the whole truth, nothing but the true self you got?
I do.
Thank you. If you want to just sign in and state your name for the record.
I'm Ellen Osgood.
Mm-hmm.
I had been dealing with Dream Barns. I found him initially because it was so adorable, sort of went with the Victorian house. He was in Alaska, and he will not draw, he does all the drawing, all the site plans, everything. And he will not do that until he receives 1/3 of the amount of money, and we didn't want to give somebody 1/3 of the amount of money until such time that we knew it could be done.
Okay.
That was the problem, and she just closed on her other house on Monday
Yes.
to have the 1/3 of the money.
So this is a little bit of a chicken before the egg.
Yes,
Yeah.
exactly.
A little scary.
All right, so,
The other thing too is, again, it's not a variance, so
yeah, it's a special exception. I realize that.
Kinsley, can you describe
What we're looking at?
what you're looking at?
I'm basically looking to put the 4-season
Take
porch.
Take the
Oh,
mic
sorry.
back.
Hello. Okay.
Right.
Is it working? I'm basically looking to, the porch is to connect the barn, because my lot goes kind of like this, so the porch is to connect the barn to the house, because the house is much higher.
In the back?
It's in the back of the
Okay.
property. It's still gonna be about, I think it's just about 40 feet from the actual, but there is wetlands on this side and no one on this side that I'm putting the barn on, so it is on the opposite side of my actual neighbors that are behind me, so I'm trying to keep it as far
Okay.
away.
Okay.
I'm very much into character and don't change, so it's any way that they can keep it exactly the same as the way my house looks now is what they're building. So it's not gonna be this big eyesore red barn. It's gonna look exactly like it's been there for the last 200 years. My house was built in 1839, I think, so I don't wanna take that away from the house.
That's good.
So same color, same roof line, same everything, and trying to keep it as Victorian farmhouse, whatever it is, as much as I can.
So then, the concern about the dogs and dogs, they're gonna bark and all that. I mean, is there a buffer, I guess, between
My house would
properties?
be the buffer. I mean, it literally will sit next to my house, so it would have my house, and then there's a good, I don't know, probably at least a 1/4 acre to an acre of land, and then, his house is like a driveway, and it's behind. I don't know the exact measurements of how far away it is. But I mean, like I said, I won't take more than 10 dogs a day. It's only me, so we try to actually work with them and not have them bark because they drive me crazy.
Right, yeah.
So
Yeah.
it's not something we're gonna just let them outside by themselves and bark all night long or anything like that. They do go away at night. They'll be inside at night, so that will also, noise ordinance that will stop.
Well, why don't we get into the special exception regarding the 4 points? I'm sorry, the 8 points. I'll have you read through. You can read the question and then read the answer and stop after each one, please.
Okay. The additions, alterations, or improvements are for a use currently permitted within the zoning district because it's a C1 property. I'm basically asking to run a C1 business that is permitted in that area.
Questions? Number 2?
The additions, alterations, or improvements are ordinarily and customary associated with the existing building and/or use, because I'm, again, trying to keep it exactly the way the house is. I'm not gonna just add this eyesore that doesn't match the house. I'm gonna try to keep it as normal as possible to what the house is.
Questions? Number 3.
The additions, alterations, or improvements would serve to promote the reuse, restoration, rehabilitation, or otherwise enhance an existing building or structure, especially an historic or ahistoric or potentially historic building or structure, because, again, it will look just like the house, staying with the character of its time. The house is pretty historic, but I'm not gonna, it's gonna enhance in a way. That property has been empty for some time. It's a mess. We're actually improving the character and look of the house by adding this and making it look bigger. It's not gonna look like a grooming and boarding facility. It's gonna look like it's an attached barn to the home.
All right. Number 4.
The additions, alterations, or improvements would not result in increased hazards to vehicles or pedestrians, impair or impede emergency vehicles' access or the provision of emergency services, or encroach on planned right-of-way corridors, because, again, we're building it more than 40 feet from the street. It's not gonna have anything to do with the front of the street or anything like that. And again, we have ample parking for the amount, I believe I read, of people working there, which is only me, plus however many customers we have, which is only, I think we said 10 dogs, so that would be 1 per 5 customers, so 3 parking spaces or 4 parking spaces, so there's that there.
Number 5.
The additions, alterations, or improvements would not result in unreasonable impacts to abutting properties by way of increased noise, visual blight, odor, or other nuisance, because no one is actually next to or behind where I'm actually putting this barn. It would be on the opposite side, as far away from neighbors as possible. Again, with noise, we're gonna do the best we can to keep them from barking, and we're not gonna have 25 to 100 dogs there, 10 dogs maximum, so it's not gonna be this obnoxious, loud noise all the time.
Number 6.
Adequate parking and other necessary support facilities would be provided for the existing building or structure, as well as for the proposed addition, alteration, or improvement. Again, there are already 5 spaces there, so if I had to put more, we could. There's definitely enough room for that.
Number 7.
The proposed improvement would have been allowed by right prior to adoption of the zoning ordinance provision at issue, because it was built before 1959, so we don't actually have to have the setbacks if we attach it to the house, which we are in fact attaching it to the house.
And then number 8.
The proposed improvement cannot reasonably be constructed in a different way or in differing proportion to the property so as to comply with the existing setback requirements, because the house itself isn't within the setback requirements, and I'm trying to keep it as far back from the street and as far away from other people to accommodate everybody.
Any questions from the board? Okay. Is there anybody who'd like to speak for or against this petition? Sir, do you want to come back down again, or? Okay, all set. I get what you're saying. I understand. They want to. You want to make sure that you can do it before you put
Right.
the money down, especially.
Plus he was in Alaska.
Yeah, no.
Right.
Hard to deal with him.
Yeah, no. All right, I'm going to close the public hearing. I guess from the discussion from the board, if you do approve the special exception, there is a staff recommendation. I'm not against it. I'm a little, I would have liked to at least seen kind of just at least a tracing of what we're looking at, but no, that's okay. No, this is actually, this is, sorry, no, that's okay. So with that being said, I guess I leave it to the board if there's any
So
discussion.
I do have a question, directed to Lynn. They would need plans for this? Okay, so there would still be more steps that you would need.
Yes,
Getting-
we're aware of that.
Okay, just,
Getting the
Wanted to make
special
sure.
exception granted tonight is no guarantee that she's gonna be able to build that barn.
Right, but in order to,
because she has to go to the planning board.
Right.
but she would still, they would have to put down the money before they can go to the planning board.
Right.
That's why it's the whole chicken before the egg.
Ah, okay.
All right. All right, or egg before the chicken, sorry. Do I have motion?
Sure. I move we grant the special exception under section 3.09 of the zoning ordinance to permit a 20 by 30 barn and four-season porch addition to a single-family dwelling constructed before June 29th, 1953. The parcel is located at 9 Harris Ave in the C1 Limited Commercial and Aquifer Conservation Districts and Wellhead Protection Area. Tax map 6D-1, lot 038, case number 2018-29,
With staff recommendations?
with the staff recommendations highlight.
And a second by Kathleen. All in favor, say aye.
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 All opposed? 5-0-0. Good
you.
luck. All right, next is Lorraine A. LaRusso, I think I said that right. Variance, applicant owner, variance under section 2.02.76 of the zoning ordinance to permit the construction of a single-family dwelling 23 feet from a wetland, whereas 40 feet is required. The parcel is located at 12 Cary Drive in the R1 Residential and Aquifer Conservation Districts, tax map 5B, lot 176, case number 2018-30. So, for the board, and Rob may assist me on this one, we're looking at three variances. We are going to hear them one at a time. And I do realize that they're all really linked to the first variance, at least the second two are. This property, if you've been reviewing your packets, was actually before us back in 2017. At the time that variance was denied for a property. The change that I've seen from the variance, and I asked Rob, was that they were looking for 20 feet from wetland, whereas now they're looking at 23 feet. They're also looking to build a smaller home and a little bit different location on the property. So right now, what we need to do in order to move forward is, or prior to moving forward with the petition, we need to make a material determination of a material change of circumstances affecting the merits of the application has occurred, and/or that the current petition is materially different in nature and degree from the previously denied petition. So before we have you speak, we're going to have a discussion with the board to discuss the new petition, as is my understanding, Rob, and then make a decision on moving forward.
Right, but if you want to let Attorney Dodge present the differences between them and try to explain that, she did, in your packet, she did prepare a big outline about how they feel their application's different. It might be worth having them run through that just for all the board's knowledge, because there were several members who were not here last time.
Good point, Rob. Thank you very much for that. I'm sorry, Attorney Dodge, if you, welcome, if you just, I know you probably already signed in while I was talking, so if you'd like to tell us what we're looking at between the 2017 variance and this variance?
Thank you, Mr. Chairman, members of the board. Thanks for hearing us this evening. My name is Laura Dodge. I'm an attorney with McLean Middleton. I'm here with Lorraine LaRusso, who is the owner of the property. Also with me tonight is John LaFave. He's a land surveyor with Meridian Land Services. We did submit a pretty lengthy application. I apologize for inundating you with a voluminous application, but we wanted to really put forth for the board to show why we felt this application was different than the previous application in 2017. On page 2 of our submittal, we lay out that analysis, and as Mr. Price had indicated, that it's a threshold matter for the board to determine if our application is substantially different from the previous one. We feel it is. The analysis the board has to consider is whether there's a material change of circumstances affecting the merits of the application. And here we have, even though we're asking for the same relief from the same section of the ordinance to construct a single-family dwelling in a residential area, Just as a preliminary matter, the structure we're talking about is different. We have reduced the size of the structure by approximately 30%. The previous applicant was proposing to build a Habitat for Humanity house. The house that we're proposing to build, Ms. LaRusso, it will be her own private residence. It will be owner occupied. And in addition to so even though it's a residential use, it's going to be different than what the proposed application was that was put forth before you in 2017. Additionally, the plan that was submitted with the previous application, they did not delineate the wetlands properly. The plan was not certified by a wetland scientist. We have engaged Meridian Land Services to prepare a plan. There is a copy of the plan in the packet that I submitted, and I also have a full size of it here if you would like to see it. But we have properly delineated the wetland area, and considering the unique circumstances of the lot, our plan with the proposed location for where the septic is going to be and where the house will be is, we feel, in the safest and the most appropriate location on the lot. So, one of the other differences that we feel with regard to the previous application is just the degree of due diligence with regard to the application that was submitted. The prior application, they didn't even address the septic issue. I mean, I realize that by the board ruling to deny the variance, it made the septic issue essentially moot. So the septic issue wasn't even addressed. The previous applicant did not apply for the wetland buffer, for the special exception of the wetland buffer. I'm not sure if that was initially flagged for them to do or not, but they missed that. So our application applies for all of the three things. We have also taken into consideration some additional due diligence with regard to the wetlands on the property. And Mrs. LaRusso has considered some mitigating measures to take into account building a house close to the wetlands and what she can do in terms of landscaping techniques and construction of rain gardens and swales, and utilizing the property the best way she can with minimizing the impact to the wetlands or any abutter concerns about water on their property. Finally, just in terms of the supplemental material that was submitted with the application, we have photos of the property for you. We have an analysis of these proposed measures that she's looking to create on the lot to minimize any impact on the wetlands. And for those reasons, we feel that our application is substantially different than the application that the board saw in 2017.
Okay. Is there questions from the board? Discussion items. I know when I went back and reviewed it, there was a lot of discussion from abutters regarding rain, water off, the fact that you get a deluge of rain, the area tends to float up. There is a culvert that tends to fall up. I've just looked back on the notes. If I remember correctly, there wasn't necessarily proper documentation by the petitioner at that time regarding the wetlands and the runoff. I would be interested in hearing, and I'm sorry, I forgot your name, sir.
Sean Lefebvre.
I would be interested in hearing from Mr. Lefebvre regarding his take on, I take it he's been to that property and done soil samples and walked around. I'd be interested in your take as far as the culvert that's there, the rain runoff, and all of that. There's a microphone right there. You can speak or you can sit at the table. But I'd be interested to hear your take on that property, because I know that was an area of concern when we reviewed the petition last time.
Hi, my name's John Lefebvre. I'm with Meridian Land Services. Let me fix this mic.
I think you can adjust it up.
I'm signing him in too.
There you go.
So our office had delineated the wetlands. Me personally, I am not a wetland scientist. Our office has wetland scientists, so someone from our office delineated the wetlands.
Mm-hmm.
Yes, they did soil sampling. When we delineate the wetlands, it's the soils that they're actually showing on the plan being the limit, the wetland soils, whereas the water would be within that. And it's no different than any of the properties in the neighborhood. If you get a good rainstorm, yeah, there's gonna be some water somewhere. But as far as the wetlands themselves, that's what we're speaking to tonight. And we have measures where we situated the house, there's no foundation drains. It's the least amount of impact that we could possibly have on this lot. We've looked at every type of septic system we could put on the property and spoke to what the best outcome would be, meeting the state standards. So I don't know if you have a technical question to.
I guess what I'm looking at is I know a lot of the questions were about runoff and about flooding, potentially flooding other, in maybe in constructing on the property itself. Once you start constructing on the property itself, even the footprint you're looking at, you're moving around soils and you're moving around. You might change, where water might flow and I guess what we're looking at, or what I was looking is to, in building in the proposed location, is that going to cause rain? I mean, because like you said, rain's got to go somewhere, right? So is it going to go in someone else's yard? Is it going to flood the street? I mean, is there enough, barring some typhoon coming through, is there enough to so we're not going to be flooding out someone else's property based on runoff?
No, we're not creating a large impervious change here. The only reason the water runs in that way is the way the road's constructed. Had it been done to today's standards, you would see like swales and all kinds of things done. And the culvert's not even on this property, it's on an abutting property. We're just speaking to our lot and where the wetlands are on this lot. So if they're speaking to a culvert, it's not even on our property.
Okay. All right.
Mr. Dwyer, can I
Yes.
add something too?
Yes.
So, and the footprint and it's shown on the plan, the proposed house is 24 by 25. Modest size house, it's not going to take up a significant footprint on the lot. It's going to be built on a concrete on slab grade foundation. There's not going to be any dredging or filling or reconfiguration of the wetlands. We're building on the dry upland portion of the lot.
Okay. Any questions from the board? Yes.
Can you describe the septic?
It's, so the septic system, once again, I did not do. It was someone from our office, Tom Carr, who's a licensed septic designer, had taken a look at where the system would be. We have a test pit we performed. There's already been a approved septic system in this location. What we've done is we've actually made it smaller. There is an Infiltrex system which treats the effluent prior to going to the leach field. And the leach field will be it's a chamber system. The whole system is Infiltrex, but it'll take up the least amount of space on the property. So we've actually changed it to an even smaller design, or looked at an even smaller design than what was looked at before.
Any questions? Further questions? So there would be 5 points to move forward?
Not 5 points on this, it's really
No, this
you
is
just gotta
just
settle
that
the
house.
question of whether or not this application, you feel it's materially different or the merits have changed.
Is there any questions for Attorney Dodge? Then I'll start the discussion. I think based upon what I've heard, I mean, there's merits to move forward. If there's any disagreement or any other questions so
I was a little skeptical, but I've heard some compelling arguments.
it sounds like, changing the house where they repositioned it, as well as, a little more due diligence when it comes to the wetlands and the soil and positioning and the sewage, the septic. I think there's sufficient to move forward with it, yes.
If we can have a formal motion, then
Not that I'll necessarily vote for the variance, but I think there's
All
sufficient
right.
to move forward.
So we vote on, so Rob, just because this is new, we've kind of, this new territory here. So we vote on this variance? So-
not the
not
variance, you're just gonna make a motion whether or not that, again, you feel that you feel that there is a material change of circumstances affecting the merits of the application, or that the current petition is materially different, whichever one of those points the board feels that the applicant has met.
I'll make a motion that, based on the discussion tonight, that there is a material difference in what's being proposed versus what was proposed last time, and therefore I think we can reconsider this, or consider it anew.
Do I have a second?
Second.
Seconded by Rich. We do, and just do official vote. All in favor, say aye.
Aye?
Aye. All opposed? All right, 5-0-0, so we can move forward.
Yep, now you consider the merits of that wetlands application that you've opened the
All
hearing
right,
for.
let me read that into the record, and then we'll move forward on that one. Lorraine A. LaRusso, did I say that, is that correct, LaRusso? LaRusso. Petitioner owner, special exception under section 2.02.7.A.4 of the zoning ordinance to permit the construction of a single-family dwelling within 12-foot wetland buffer. The parcel is located at 12 Cary Drive in the R Residential District and Aquifer Conservation Districts. Tax map 5B, lot 176, case number 2018-31. Did I read it out of order?
We're on number 7, aren't we?
I read
The
that.
one you should be doing now is the wetland setback of 23 feet from whereas 40 is required.
Oh, I'm sorry.
Number
I
7?
apologize. I apologize. Yep, no, I took it out of order. I apologize. I scratched what I just read, and let me put in let me read the other one in. I apologize. Lorraine A. LaRusso, petitioner owner, variance under section 2.02.7.6 of the zoning ordinance to permit the construction of a single-family dwelling 23 feet from the wetland, whereas 40 feet is required. The parcel is located at 12 Cary Drive in the R Residential and Aquifer Conservation Tax District's tax map 5B, lot 176, case number 2018-30. Apologize, we're looking at case 2018-30.
Yes, thank
Again,
you.
sorry. Go ahead.
And because there's so much overlap with regard to the house and the septic, obviously, I'll address the house being within the 23 feet from the 40-foot requirement, but the analysis kind of addresses, I've interwoven it together in my application material for the septic issue as well.
Okay.
So we are seeking a variance tonight because of the location of the home and this proposed septic system relative to the wetlands on the lot. It's a small lot in a residential subdivision. The subdivision was approved by the Town Planning Board in 1967. There's 85 lots in that subdivision, and they're all residential uses. What we're proposing is the construction of a single-family home, which would be consistent with those additional uses that are in the area already. And due to the small building envelope with which we have to work because of the location of the wetlands and the configuration of the lot and our limits with regard to where we could put a structure on the lot, we felt that the plan has the best location to appropriately and safely place the home and the septic from the wetlands. Unfortunately, we don't meet the 40-foot requirement, and we're at the 23 feet from the wetland setback. So going through the variance application and the criteria, the 5 criteria, as the board knows, granting the variance will not be contrary to the public interest, and the spirit of the ordinance is often construed together, and this is because the spirit of the ordinance is essentially to promote the public interest. So a variance will not be contrary to the public interest unless it unduly and in a marked degree conflicts with the ordinance such that granting the variance would violate the ordinance's basic zoning objectives. So looking at that, we go to what are the basic zoning objectives of the Merrimack ordinance. And those are to promote the health, safety, convenience, and general welfare of the town and to make it an attractive place in which to live. There's also a purpose embedded in the wetlands ordinance that says that it encourages uses that can be appropriately and safely located in the wetland area. Ms. LaRusso's plan does precisely just that. We have identified the best possible location on this lot to put a house and a septic. Again, as John LaFave said, we have constructed the house to be on the upland portion of the lot. It is a smaller home. It takes up a relatively small footprint. It's going to be on a concrete on-slab grade foundation, and it is not going to encroach or be in the wetlands at all. The proposed location of the home will not alter the essential character of the neighborhood. Again, it's a residential neighborhood. There are other single-family homes in the neighborhood. What Ms. LaRusso is proposing to build is a single-family home that will be consistent with those homes in the neighborhood. And the home and the septic is necessitated by the size of the lot, taking into consideration the wetlands. The side property line where the 20-foot is required for the septic, we are asking for to be within 10 feet because, again, if we shift the house and move the house further into the lot, we then encroach further into the wetland. So we're limited in terms of where we can put the proposed structure. The proposed house and septic location are not harmful to the public health or welfare because Ms. LaRusso intends to utilize ecological landscaping techniques to minimize any potential impact on the wetlands. In the packet of materials that we had submitted behind tab number 6 shows some considerations that we've taken into with regard to different landscaping techniques that are available, different types of vegetation, different plants, rain gardens that you can do to try to capture water, to minimize any impact on water saturation on the lot or flooding concerns. The use is reasonable and consistent, as I said, with the 1967 subdivision because it contemplated that these lots would be used for residential single-family dwellings. That is what we're proposing to build. And finally, with regard to addressing the zoning or the ordinance and the spirit of the ordinance, we feel, and as Mr. Lefebvre has noted, that this isn't going to displace more water. It's not going to create flooding on any other lot. It's not going to adversely impact those other lots. That culvert is not on this lot. It's a vacant lot. It is the design and the plan that we've put forth we feel is the most beneficial in terms of the type of house that you could build given the confines of the lot in this wetland area. Do you want me to move to 3 or do you have questions?
Well, hold on. So that was 1 and 2. Any questions from the board? Number 3, please.
Okay. Granting the variance would do substantial justice. Here, the board, this is essentially a balancing test, and the guiding rule is to determine whether the loss to the applicant outweighs the gain to the general public. Here, without a variance, Ms. LaRusso cannot build a house on the lot. Due to the size of the lot and the location of the wetlands, there is no place you can put a house on this lot with meeting strict compliance with the 40-foot setback or the side property line. So there's no real, impact to the general public. If anything, it's a vacant lot, and to build and construct a house on this lot, I think will actually be beneficial to the public. Ms. LaRusso has been over to the lot since she purchased it, and apparently there's been some activity, empty beer bottles, spray painted trees, things like that. So I think if anything, this improves and enhances the general public's interest in developing a lot that's there that was planned to be residential, and that it would have a home. It would be owner occupied. Somebody would be looking out for the property, and some of the activities of vandalism and trespassing wouldn't be occurring if there was a home constructed on the lot.
Can I just have a question about what you just said?
Yep.
So, regarding the comment about beer can and spray paint, what was the nature of the spray paint? Did it look like markings of trees that needed to be cut down, or was, I guess my question is, what was spray painted?
There's several trees that were spray painted in very large letters from maybe a height of 30 feet and down. One tree had gang on it, G-A-N-G, one letter under another. spray painted in green. Another tree had gang in orange, and there was some sneakers thrown up on the branches, and lots of beer cans, and so, you know, those trees will, it's unfortunate that somebody has, you know,
Okay.
marked them.
No, I appreciate, I was just curious. Thank you.
So, continuing on the substantial justice criteria, the board considers, you know, whether the proposed use is consistent with the area's present use. And again, the area's present use is that it's a relatively large subdivision of 85 lots with single-family homes. There are only 3 lots that are vacant. Mr. LaRusso's lot is one of them. There are 7 lots within that 85-lot subdivision that are smaller than her lot. Presumably, and I understand the town doesn't maintain a wetlands map. They rely on the UNH Cooperative Extension Wetlands Mapper, but presumably the area is wet. It does have wetlands, and there's other houses in that subdivision that have either built within or haven't met the setback requirement. The 40-foot setback requirement wasn't an ordinance until 2000, so one of the important things too to note that's in your application is that the lot does qualify for the legal non-conforming use because the subdivision was approved prior to the setback requirement changes, so. So essentially, what we're asking is giving her the same right to build a home in that subdivision that others have done, that perhaps did most likely prior to the wetlands ordinance. And, you know, to deny her a variance would be a substantial injustice because there isn't really a gain to the public. And here, she cannot build the house on the lot at all without getting some kind of request for a granted variance for her to build in the location she's proposing to build. The home can be appropriately and safely located in the upland area of the wetland, of the lot rather, and she is going to, again, has considered things like a semi-permeable driveway. The landscaping mechanisms that she's looking into. Certainly the last thing she wants to do is build a house on a lot that's going to be, you know, that's going to cause problems with the neighbors. She wants to work with the neighbors. She wants to live there. She wants to maintain a harmonious home with the wetlands to not, you know, impact any kind of relationship with the neighbors or disrupt the landscaping that's there. And she's not proposing to clear the lot and take down a ton of trees and, as I said, to dredge and fill the existing wetlands.
Good question.
I have a question.
I understand the intent of the landscaping and the driveway surface and all of that, but if we grant this, there's no guarantee that she has to do that. She can let it sit the way it is. She can do anything else on that property that she wants to do. I understand the intent is there.
Unless you grant it with conditions that she does do it. I think the board could impose conditions
I
on-
don't know that, can we do it at zoning level? And who would,
How is that enforceable?
right,
That is certainly a question, but you certainly can impose conditions.
can a building permit be subject to those conditions? Like I said, I understand the intent, but
If you're granting the variance, it's going to allow the use of the lot. I'm really honestly not sure, because I don't deal with the building permits and what they get into. So,
I think if we're gonna go down that road, we should probably consult town council.
I think let's hear out the rest of
Yeah,
the
let's
petition
continue.
first before having the discussion. We'll table that for the moment. You can finish off on 3 if you're.
Yep, I'm ready to go to 4, the values of the surrounding properties, unless there's any other questions on 3.
Let's go to 4.
Construction of the proposed home will have no negative impact on surrounding property values. We have submitted a comparative market analysis and an opinion from a local real estate broker who opined that actually constructing a home on this lot, not letting it stay vacant, putting a new home with some of these measures in place that would add value to the property and the neighborhood. The design, the location, the construction of the home are all consistent with those existing homes in the neighborhood. It's not going to be something that seems like it sticks out or that just doesn't fit. It's not going to alter the existing character of the neighborhood. And again, it will be owner-occupied. It will be well-maintained, and the concern we had raised earlier about leaving it vacant, we felt would negatively impact property values.
Questions? Unnecessary hardship?
So literal enforcement of the provisions of the ordinance would result in an unnecessary hardship. Here we look at owing to special conditions of the property that distinguish it from other properties in the area, denial of the variance would result in an unnecessary hardship because no fair and substantial relationship exists between the general purpose of the ordinance and the specific application to the property. The property does have special conditions. The fact that it's small, the fact that it's only really, there's only a few lots in the 85 lot subdivision that are smaller. And this distinguishes the property, and the fact that it has the wetlands at the back portion of the lot and on the side make it such that it is a limited buildable lot where you can effectively put a house. Additionally, the plan was designed, as John had said, with these conditions in mind. They delineated the wetlands. We went through various reconfigurations of the size of the house. We wanted to make sure that we proposed a house that was going to meet minimum building code size. We wanted to reconfigure the house such that we could minimize impact into the wetlands as best as we could. And the plan that we have submitted, we feel, is the best plan to appropriately and safely locate the house and the septic. The variance is necessary because, as I said, there's no other reasonable place on the lot to put the house. And no fair and substantial relationship exists between the purpose of the ordinance and the specific application to the property, because the plan before you, it doesn't impose an impact, a negative impact on the wetlands, because we are not within the wetlands. I know we're going to address the wetland buffer issue, and we've got a special exception application before the board for that. But the plan that we have, as I said, is the safest and the most appropriate spot on the lot, given the unique characteristics of the lot.
The proposed use is reasonable?
The proposed use is reasonable because it's permitted. It's permitted under the town zoning ordinance. It is a single-family residential home in a residential R1 district, the Aquifer Conservation District. We are, again, constructing a single-family dwelling that will be consistent with those existing uses. It's not going to alter the existing character of the neighborhood, and it's a use that is permitted.
Does everybody feel that unnecessary hardship has been met? Is there any?
No.
What?
You bought the house knowing that there had been a variance requested and had been denied. And you bought the lot anyway. And for some reason you thought you could do it anyway? I don't understand the hardship. You bought it knowing that there was an existing problem.
Well, I bought the lot in May, thinking that I would be able to build a house, because nobody has tried to do the due diligence on it to see if it was a buildable lot. If somebody said, oh, I went to the board and we did all this due diligence, and we did all the investigation and the research that we have done here, and they said there's no way we can build on this, then I wouldn't have. But since nobody did that in the past, in the Habitat application last year, it's my understanding they didn't do the extensive planning that we have done. They didn't do a wetlands map. They did not do a certified plan for the house lot. And And so I didn't feel like they had met the standard that I wanted to meet. So I purchased the lot and in hopes that I could build a house on it. I think it's a good lot. I think it's very doable. And I think we've done some very careful planning as far as not building on the wetlands. We're going to build on the upland, and it's not going to disturb to any great extent. I'm not clear cutting the lot. I'm not putting in a grass lawn. It's going to remain in its natural state, other than putting in a permeable driveway, some rain barrels and swales, and putting the house in as, as gently as it can be built.
I understand you're not building in the wetlands. That wouldn't fly anyway.
Yeah.
But there's a reason that we have these buffers. And you're asking for a variance on a number of these setbacks and buffers that just doesn't say to me that this is a buildable lot.
Well, one of the things
I know you've got a lot of detail in here.
One of the things I did consider too, which I thought was an important feature, was that there doesn't have to be a drilled well on the property. We have town water. And that was important because if the requirement was that I have to drill a well, it would never have worked. So that was another characteristic of the lot that I considered before purchasing it. Where it had town water for drinking water, I felt more comfortable with putting in a small septic that's eco-friendly and then a small size house.
When did you start researching the lot?
Way back in February. And I looked at it, talked to a lot of people, and what I kept hearing from different people was that it has never been built on. And I said, well, how much research has been done or consideration, or has anyone done a plot plan on it? Has anyone looked at, I couldn't find a certified wetlands map. I looked at the information from the Habitat people had submitted, and it was more and more in my head that not enough research had been done. If I come to a point where I thought that the house would encroach on the wetlands and destroy it, I wouldn't even consider building it.
Do you have a history of knowledge on wetlands, and you say you did a lot of research?
My undergraduate degree is in biology, so I'm very aware of marshes and wetlands and habitat and environments.
Okay.
I kind of, I see what you're saying. I see where you're going with that, Lynn. But I mean, I guess the property's for sale. I mean, obviously it's a buildable lot. It's just a matter of doing it with the least amount of impact to that.
It may not be a buildable lot.
Then-
Legally, it may be, but in actuality, it may not be.
Then that should be something the town shouldn't have property like that up for sale for folks if they're, so,
Well,
but that's a
can sell
whole other
it.
story, right?
And I just wanted to add, one thing that we discussed when we were evaluating this application, knowing that the previous application was denied by the board in 2017, was looking at their material and looking at their plan and seeing how they didn't delineate the wetlands. So we felt, well, if someone really goes out there and delineates the wetlands according to the Army Corps of Engineers and identifies where the wetlands are and whether this in fact is a lot that we can put safely a structure on. So that was an analysis that we undertook too before, submitting our application.
So you had the Army Corps of Engineers go out to that lot?
Well, they follow the manual and the techniques laid out for
Meridian did it.
how you properly flag and delineate wetlands.
Given the questions regarding the first two sections of the unnecessary hardship, there's a third section, B.
The alternative
Yeah.
section?
If you could just read that into record as well, please.
Yep. Alternatively, an unnecessary hardship will be deemed to exist if and only if, owing to special conditions of the property that distinguish it from other properties in the area, the property cannot be reasonably used in strict conformance with the ordinance, and a variance is therefore necessary to enable reasonable use of the property. Here, there is no way you could build a house and a design and locate a septic in strict conformance with meeting the setback, 40-foot setback for the wetlands and the 20-foot setback from the side property line for the septic. Again, we took, as I said, we manipulated this as much as we could to find the best scenario where we would meet the minimum building requirement for the square footage gross living area of the home while trying to decrease the amount of feet we were encroaching into the wetland or the buffer. And this is quite honestly the best plan, given the small lot
I
size.
have no argument with that point.
I'm sorry,
I
what?
said, I have no argument with that point.
Yeah.
Okay. Any other questions from the board? Comments? All right, if, I think there's some people who are gonna probably wanna speak for and against, if you guys just wanna
Okay.
slide over. So we're gonna open this up to the public. If there's anybody that would like to speak for this petition, please come down. If there's anybody that'd like to speak against this petition. Announcer, were you sworn in?
I am.
Oh, you are, okay, come on down, if you could just sign in and state your name for the record. And just make sure the mic's right in front of you.
My name is Aiden Seltzman-Wilps, and I am the abutting neighbor.
Actually, is the mic on?
Is it bright?
Is it right?
Ah, there we are. Aiden Seltzman-Wilps.
Yep.
I'm an abutting neighbor at, I reside at 8 Cary Drive, and I also own 10 Cary Drive, which is the immediately abutting property, which I believe is the wetland in question for much of this, at least the discussion of the wetland off to the side of the property. We have been here before. Couple of notes. I appreciate the board's discussion of what exactly would be the enforcement of special conditions on construction techniques. I appreciate the owner's discussion of different techniques. I have yet to see details of what those are and what the performance metrics of exactly what they would do or how effective they actually are. Because first of all, I have to state I'm adamantly opposed to this because my property suffers significant water, standing water, not even on an irregular basis, but on a fairly regular basis. I have a number of photographs of the property taken today that will show.
I hate to interrupt you. Can you show me on this map what your property is?
That's me.
Okay.
8 and 10 Cary Drive.
Yeah, all right. That's why I had him show me. So you're looking at this property here?
Right.
And then the one next to it?
Yeah, the blank lot next to it is 10 Cary Drive.
174, 175?
Yes, 174, 175.
So 10 and 12 are both vacant.
Yes, yes, they are.
Okay.
So my lot 10 is unbuildable, I believe, because of the wetland. So essentially, one of the first things is, so we have an environmental assessment now that is more thorough, or at least appears to be more detailed than the last proposal, but I think that it would behoove the town to, as Ms. Christensen stated, seriously look at what is the reality of this lot now. The property was, like you said, approved, was it 1967? Or when it was originally set up as a buildable lot. I would propose that lot's geography and the reality of that lot has significantly changed in those years since. It is a bog. We have heard discussions of we're gonna build on the higher elevation. I'd really love to see what the elevation change is here of that lot, because I don't see it being much more than a foot or two. I don't think we're looking at building a house on a hill. We're looking at,
No, it's,
it is what it is. I'm concerned about the fact that our sump pumps, and my other neighbors here will also attest to, our sump pumps, our French drains, our drainage systems at our houses are barely keeping up with the reality of the situation in that neighborhood right now. If the town does grant a variance in this particular situation, what assurance do we have as neighbors, or what mitigation techniques are gonna be put in place? And what assurance do we have that it's not gonna cause catastrophic damage to our homes, most of which are split levels with submerged basements? That's something I would like to hear. I mean, what the reality of that is. I understand. I've heard a few things about that. This is the best option for that property. I submit that the property is beyond the point of a realistic option of putting any type of residence or structure in there without a negative impact to all of us surrounding the property. We all have significant water issues. The entire development has been essentially overdeveloped and overcut. There are far fewer, all the trees have been cut away over time. More and more driveways, more and more houses have been built. It's just everywhere you look, it's a bog if it's not your driveway or your house. So as to the hardship on the owner, this property has been up for sale several times. It's been non-buildable, or hasn't been built on since it existed, to my knowledge. The property value in the past year and a half, or at least the for sale prices, dropped from, I think, in the vicinity of $30,000 down to almost, I think it was below $10,000. So that sounds like a fantastic deal to someone prospecting for real estate. But I put forth that this particular piece of property never would work. And I appreciate the argument of a hardship, but I think with due diligence and understanding and the research or communication with people around the area, there's been no, to my knowledge, no interaction with the neighbors that have lived there for decades and understand what that lot is like and what it always looks like. I've never been approached. I live right next door.
So when you showed me on the map where you are, and then there's the property next. So you bought the wetland property next to you.
It was it was part of the purchase of my house. There were two lots that came together with the one purchase.
Okay.
Yeah.
How far down would this individual would Ms. LaRusso's house be from your property? Because it looks like they're building it on. So your property's here. You have this property here. And then her property's here, and they're building it on the far side of that
Right.
property.
Yeah.
So how far down is that from your?
I haven't seen the exact location of what the proposed slab is going to be or anything like that, but I would estimate from the edge of 8 Cary Drive where it's a yard, that property line, I would guess that's probably about 200 feet of bog.
And that would greatly affect your property that far away? I'm curious. I'm just asking.
Yeah, no, I'm asking for a better understanding of why it wouldn't. When you put asphalt, hard surface, clear out trees, put a residence and all that, where does that water go?
Right.
You know? And I'm asking for more details of why it would work. I'm not saying it wouldn't, but
And there's no sewerage on Carry, so there's no sewer on Carry, so there's no
septic's only.
runoff, or, okay.
Right,
So
yeah.
it just basically ends up in the road or in the soil, or?
Certainly
Yeah,
does.
it's absorbed in the ground, okay.
Yeah, the road's got a
All right.
couple of sinkholes going on at the corner of Cary and Maidstone right now. That have opened up. There's the asphalt that overlies, everybody's been talking about the culvert. The culvert is, yes, it's on 10 Cary Drive, which is my property. I'm not necessarily concerned about the culvert per se, but the road is taking it's taken some hits.
Okay.
It's gonna need some repaving because of winter frost heaves right over that culvert. It's getting torn up, but.
So, and then what about the mention of vandalism in that area? I mean, is there a concern there? I mean, this is it's right next door to your property.
Yeah, it is
I mean,
right next to Bourne-Novick property. You know, quite honestly, I honestly haven't gone that far back into, well, it's not my property anyway, but I haven't gone that far back into there just because it's kind of almost impassable. I would need hip waders most part of the year to get back there.
Okay.
I've got, I don't know if it's admissible or anybody wants to see it, but I've got photographs on an iPad that show what it looks like today.
No, I mean,
Yeah,
that's okay. I mean, we drove out there in 2017 and looked at the lot, and I'm sure
Right.
we've done it recently as well, so.
As to the vandalism, it's a spot in the woods where local kids probably end up. It's woods. Okay. I mean, when we talk about a vacant lot, we're not talking about bare dirt and asphalt with cigarette butts and derelict cars in it. It's just woods.
Okay.
The neighborhood kids eventually find someplace to hide out. Probably.
I mean,
it might be it, but.
So the potential of maybe the potential, if granted, of having a home there. I mean, does that add any value of security? I mean, these people are the kids are in that yard, but they're how far are they from your property?
Sure.
And they get hurt there, and the whole
Put it this way, sir. I have never been.
Yeah.
I've lived there for coming up on 12 years now. I have never been actually aware of anyone back in that property. I've never seen anyone. I have heard of these spray painted stuff and trash here and there and stuff in the woods. I have never known myself of anyone actually being back in there, nor been disturbed by it. I'm not aware of any impact of any additional crime in the neighborhood that's gone on because of anybody being in there. So,
What would you? I'm just kind of curious. And what would you want to see? I mean, what do you think that should be done with that land? I mean,
ultimately, I think we have a lot that shouldn't exist. I really do. I have no hard feelings towards any of these potential buyers and what their plans are. And in the past, we've seen some rather honorable attempts to, Habitat for Humanity home. That's great, but I don't have an assurance that lot is even viable for anything, other than I don't know, Habitat for Frogs.
yeah.
I just don't see it, and if we were to push forward, I think the entire neighborhood would need some significant reassurance that we weren't damaging their properties as a result of whatever was going to happen, and I just haven't seen that yet.
Cool. I mean, I just okay. No, I appreciate that.
Okay.
Is there any other questions, concerns? All right,
Thank you very much.
Based on his testimony, I mean, if somebody just wanted to put a garage up, that could be an issue. Or somebody wants to put a porch on their house or do any major changes like that, that could be a major issue, so, interesting. All right. Is there anybody else that'd like to speak against this petition? Come in and just sign in and then state your name for the record?
I have not been
Sign
sworn
in
in
for-
yet.
Oh, you haven't been?
No.
Okay, well, why don't you sign in? I'll swear you in.
Just raise your right hand. You swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
State your name for the record.
My name is Jeff Dittman. I live at 7 Cary Drive. I live directly across the street from Mr. Wilkes, who just spoke.
Okay.
So I'm not a direct abutter of this property, but there is some effect from this lot to my property, number one. And number two, I'd like to address and refute some of the points that Attorney Dodge made. Okay.
Go ahead.
My points aren't necessarily in order, so if you bear with me. You talked about the vandalism, so-called vandalism of this lot, and yes, there have been beer cans and some litter at this lot. By the way, I've lived in my house for 33 years, and I have never seen any people in the woods in this lot. I do understand that there have been some instances of people in the woods. I've never seen these trees that are spray painted.
When you say instances, are you referring to instances in which law enforcement's been called? Are you referring to just seeing them yourself, or just hearing about it?
All of those.
Okay, so
Yeah.
police have been called to the area then?
No, they have not been called. What I was going to say was that there's never been any vandalism on our street that I'm aware of, and definitely not in my house, as I said, over 33 years. And my wife tells me she's seen some people in the woods, but I really think that that is a non-issue as far as any vandalism or issues with this lot. Okay. During the first 5 years that I lived in my house, I'm sorry, the first 5 years, my basement flooded 3 times. So after that, I did install a French drain and a sump pump, and fortunately, it's worked over the remaining years, and I haven't had any problems. But the sump pump does run often during the wet parts of the year. A point was made about this house conforming to the character of the neighborhood, and I disagree. This would be a very small house. It would be 20 by 30 or 600 square feet, I believe, is the proposal. And I assume that there isn't going to be a garage on the property as well. Most of the houses, like my house, is 24, and actually it's 70 feet long if you add in the breezeway and the garage. And most of the houses are of approximate size. So I believe that this house would be out of character because it would be a small 2-bedroom house. And the value would obviously be a lot less than corresponding houses in the neighborhood, because most of the houses, for instance, my house has either 4 or 5 bedrooms, which is probably typical of most of the houses on the street. In this house, we only have 2 bedrooms. If this house were to be built, and let's say it would be subsequently sold, that I believe it would affect the values on our street, because of the fact that when you look at comparable sales, you do look at houses in the surrounding neighborhood. And even though I'm not a real estate agent, I have looked at many real estate appraisals, and I know that comparable sales in the area are looked at, and I think this might drag down the value of some of the houses.
Generally speaking, when they're looking at comparable sales, they look at sales that are comparable to the size of the house that you have. So I understand the concern on it, but if you have a 2,700 square foot house, you're not comparing that to the size of a 600 square foot house for real estate value prices. But I do understand what you're saying.
No, and I understand what you're saying too. But I mean, our houses aren't that large. But still, the fact that this house would be in the neighborhood, I believe it would be out of character with the neighborhood. I know the attorney made a point that she has an opinion from a real estate agent, and that is, as she said, an opinion. I'm sure that you can get an opinion from 10 different real estate agents, and 5
Just
of them
like 10
would.
different attorneys.
Okay.
Okay. We appreciate the fact that the owner of the property has done much due diligence, and she's hired a lot of professionals, and she apparently has gone well beyond what has been done in the past. But I think that doesn't take away from the fact that the buyer must beware. Yes, it would be a hardship if she was not able to build, but the buyer has to be aware that when they buy a property like this, knowing that the prior application was turned down, that there was the potential for her application to be turned down as well. Another story, if you will, that there's a lot next door to my lot, which is a little bit closer to the property in question. I believe it would be, I don't know, be 9 Cary Drive. It's a small lot, and the person who owns the lot did want to build a garage there, and I believe his building permit was denied because the property is wet and has wetlands. And so he did end up building a freestanding structure, which I believe he was allowed to, according to town rules. But the fact is, he couldn't get a permit to build. He, when he was clearing his lot, he had either a large tree stump or a rock that he excavated, and he left a large hole temporarily, and then we had a fair amount of rain. The hole filled up all the way to the top with rain, just to give you an idea how much, how wet the properties are. For whatever it's worth, Attorney Dodge has said that the area is an 85 lot subdivision, which may be technically true. Our street, Cary Drive, only has 7 houses on it. For instance, I believe I have 2 lots that make up my property. So just to put in perspective, there's only 7 houses on our street, and so this potentially could make 8. Honestly, I feel that if she bought this house, I think that she may end up regretting buying the house, because I think she'll find that even though she has done a lot of due diligence, she's trying to find the best place for the house to be built. The fact is the lot is still very wet, and it will remain very wet, and probably be even more wet because of some of the trees being taken down and the water being displaced. And one last point I'd like to make is that she says she will cut down only a minimal amount of trees at this point in time, which I can understand, but what's to prevent her from taking down more trees in the future to enlarge her livable space, whether she wants to put in a backyard, so on. And again, not being a scientist, but I understand that these trees do absorb water, and there will be less trees around to absorb the water. So obviously, you can tell I'm very much against this proposal, and that's it.
All right, thank you. And you're absolutely right. I mean, once somebody has gone into the property, and then, you know, they can kind of, you know, you can do what you want with your property. Unfortunately, for Ms. LaRusso, she's kind of really bound by only being able to do so much, because a majority of her property is wetlands. She can't necessarily go into the wetlands and start cutting down trees and clear cutting. That would cause a whole certain other issues that would be in for her if she does that. So there's only so much cutting or removal of trees. But you're absolutely right. There, you know, it sounds like there's a couple of trees that are going to need to be taken down, and obviously that's a concern. But you know, as far as going into the wetlands, unless those were no longer deemed wetlands, there's really nothing you can't go in and cut down those trees that are in that area. But I do understand the concerns, and you bring up some very valid points. I appreciate it. Thank you.
Okay.
Thank you. Is there anybody else that would like to speak against this petition? Just come on down. And just have you sign in. You're swearing in
I am
early?
not, actually.
Okay. You could just sign in. I'll swear you in right after.
Yeah.
Swear to tell the truth, the whole truth, nothing but the truth, so help you God?
I do.
All right. If you
My
say
name's
your
Eric
name.
Gaska.
Yep.
I live at 19 Maidstone Drive. My property actually is right across the street from where she would like to build.
Ah, okay. I see your house.
Okay? The culvert is actually kind of in my backyard.
You're on the corner of
I'm on the corner, yes. My driveway is actually on Cary, and my mailbox is on Maidstone. I actually spoke with the woman who bought the property before she bought it, and told her exactly what was going on. She knew prior,
You told Ms. LaRusso?
Ms. LaRusso,
Okay.
verbatim, because I was here the last time, and I explained to her exactly what happened. So she knew before she bought the property what was going on. I think the issue that we're all having here is where the water has to go. Right now, my backyard is a swamp. The wetlands are in my backyard. Prior to me, I've been in the house for 5 years now, 6 years, 5 years. So before I purchased the property, where my property is, it used to be grass. It's no longer grass. The water has basically taken over my whole backyard. It's basically swamp. So I think that's basically what we're all concerned about, is where the water is gonna go, what's gonna happen to the properties that surround everybody else. As far as somebody walking back there, I can tell you, I watch the neighborhood like a hawk. There are no kids that go in there. Actually, there is one kid that lives across the street. They might go in there once in a while. There are bear cans, like somebody has already said. But for the most part, I always know what's going on. There's no trouble. We're not, my daughter walks to my neighbor's house, who's 11 years old. If there was trouble, I wouldn't let her walk down the street. I am in the business. I am a contractor. My big thing, like I'm saying, my big thing is where the water's gonna go. If this was denied the first time, this is kind of getting to the point where something needs to be said about this piece of property, because I almost kind of feel like we're wasting our time. I feel bad for whoever. I'm sorry for the woman that bought it. Just bear with me 1 second here.
That's okay. Take your time.
And that's really about it. I mean, I know she bought the property on the cheap, so it's kind of, I knew the property was for sale. I could have bought it and put this to rest, but I know that there's not really much you can do with it. It's a swamp. I've never walked back there. I literally walk by that 4 times a day. My trailer is parked right across the street. It's a swamp. So, I mean, I've actually met a surveyor. It's not this gentleman that's sitting in here, but the same guy has surveyed that property 5 times. I don't know his name. If I knew it, I wouldn't tell you, because I'd probably get the guy in trouble.
That's okay.
But he's point blank said, they keep sending me out here wanting a different result, and I keep going back saying it's not a buildable lot. They send him back out, he does it again. So, I mean, it's just kind of...
What, you said you're a contractor. What type of contractor?
I do general remodeling.
General remodeling.
Yeah. I don't build houses, but I've done new construction for other people and stuff like that, so.
Okay. And looking at that land, and as far as what's not wetlands, and I mean, I'm not looking for professional opinion
Yeah.
by any means, but I mean, you say you look at it, there's no dry spot in there. There's no area that it looks like you could put a slab foundation.
It's like a needle in a haystack.
Really?
And as far as setting the house on a hill, I would really like to see it, because I know the Sultan Whoops, I've seen everybody's properties, and it's always if we get any rain at all, if I walk in my backyard, even if it's dry, it's still walking on a sponge. I'm sure there's somebody else who would like to speak here. Her property is actually on the back side of it, and I think she gets the worst of it. She basically has a pond in her backyard. Even during the dry season, it's bad. So if the structure's gonna be towards the back side of the property, I think it's gonna be even worse for her. The water's gonna push back towards her property.
Okay.
So I think we're all just more worried about what's gonna happen to ours. We're kind of looking out for ourselves here. So,
Okay.
all right?
All right.
All right,
Thank you very much.
Yep.
Appreciate it. Is there anybody else that'd like to speak against the petition? Just come on down. Hi.
Hi.
I don't think you're sworn in, are you?
Right at the beginning I did.
You did? Okay, great. If you could just sign in and then just state your name, please.
My name's Christina Coviello.
Hi.
I reside at 145 Babusick Lake Road. I would be the backdoor neighbor to Lorraine LaRusso.
Babusick must be over here.
I just wanted to start out by saying that it kills me to crush somebody's dreams, because when you come in and you come before a board, you're looking for approval, and she probably had some great ideas on what she wanted, but I agree with Lynn. When you buy a piece of property, you got to know the history of it. And in doing due diligence and purchasing something, you can have great ideas, but you got to know if someone got denied before, there's a reason. I also have pictures from today. Just the light rain we got, my yard's flooded. My yard is always wet, and my fear is, where's the water gonna go? My son went out with his boots on when I took the picture. It's up at the top of his boots just today. That wasn't last week when we got all that heavy, heavy rain, because I have just literally ducks swimming in my yard, because the yard gets so wet and it fills up with water. So my fear is, if any of that property is moved or changed in any way, I'm just gonna get even more water, and we already have a lot of it. So I think my biggest fear is, where's it gonna go? And I'm pretty darn sure I'd like someone to show me and guarantee me that I'm not gonna get even more coming towards my property, because I'm just really concerned about the damage that it's doing to the property.
You have no drainage off your property at all, or
No.
no way to drain it out to Babusick?
No, we're surrounded by water on the left side of the property. It goes around the back and right out to where the bog that they called that.
You're
Marine's trying to
set
build
back
on.
quite a bit, aren't you, from Babusick?
Yes.
Yes.
Yes, which means where our home is closer to the back where the building is. Yeah, as Eric mentioned, even on a dry day, our yard is wet-ish. And even the tiniest bit of rain, God forbid the downpours that we get, fills the land up. And that's my biggest concern. Like I said, not to crush anyone's dreams on wanting to build a home. I feel bad about that. But I do agree that I really feel like it's not a buildable lot for a home in any way, because that displacement of the water is going to go somewhere, and I fear it's going to come towards us, at least some of it. And that's my biggest concern.
Okay. Any questions? Lynn? Thank you.
Thank you.
Is there anybody else who'd like to speak against this petition? Okay. Attorney Dodge, if you'd like to come up and address the comments?
I would, thank you.
I have a question about something on these maps that doesn't add up.
Can you put your mic on? Is this question for me, or is
It's
it
a
for the board?
question for whoever can answer it. I'm looking at this, which was part of your package, and I need that to show.
I don't recognize that. I don't think that was part
Okay,
of our package.
I need that piece of paper so that I can show it to the attorney.
What you're holding up is the aerial photo that was provided
No.
by staff.
This was in section 3.
Yes, you may approach. Actually, you take the mic with
You
you.
can come up and just look.
All right,
Come up
sorry,
and just
yeah.
look, and we can both share the same mic. Is this Cary or,
It's Cary.
so it's mislabeled?
This was the 1967 subdivision, and it was originally identified as Canterbury, but this is Cary, and this is.
This is what we're
LaRusso's
talking about?
lot. Correct.
Okay.
Yep.
Now it's clearer.
Right.
So,
Thank you.
Yep.
I know what I'm talking about, I'm looking at it.
So, to address the abutter comments, and I understand the concern, we anticipated that there would be this issue and the concern about water. I think to distill this down for the board, ask you to focus on, there's two things at play here, right? So Mrs. LaRusso has a right to develop her property. It is considered a buildable lot by the town. She's proposing to put a single-family house in there that's consistent with the other single-family homes. She does have she does have rights to develop that property. On the same hand, we do have to consider the issues raised by the abutters. And in New Hampshire, we've adopted the law of reasonable use. It's the doctrine of reasonable use, that one can't do what they want on their property that's going to cause a nuisance or harm to a neighbor or an abutting property. We don't have, the abutters are saying that their water is a problem. It's a problem now. We don't know. Maybe this is going to solve the problem. Some of the trees in the lot are dying. They presumably are not absorbing water. Maybe by proposing with this plan and building on this lot, it may very well help. So I think we're conscious of the fact that they have concerns. We're certainly not proposing to do anything that's going to cause a nuisance or disrupt their property or negatively impact their property. But we do have, Ms. LaRusso does have a right to develop her property. We felt with Tom Carr, the certified wetland scientist who went out to delineate the wetlands, who looked at it, who felt that this isn't going to negatively impact the wetlands as they exist on the lot or cause any negative issues for the abutting lot owners. I wish I had a crystal ball and I could say it's not going to create water issues, but the evidence that we have before us is the best thing we can look at. The abutters have presented no evidence that says, other than their opinion, that says that it's going to create more issues for them to deal with water and drainage and things like that. The town does have the drains that are on the street. The culvert does run under the property and to the left. Ms. Coviello, who's at 5C82, that lot, actually the water flows according to how, this is in, I believe this is in your packet, but this is the large wetland area that's at the back. This is the back of the 5C82, which is shown on the plan here. And when Meridian had delineated the wetlands, the flow from that actually comes from that lot into Miss LaRusso's lot and through. So it's a question of, yes, there's water there now. They all admit there's a problem with the water there now. We don't know if that's going to be exacerbated by what she's proposing to do. We can look at the evidence that we have, the plan that we have, the land surveyor's work that they did to say this is what we recommend. Build on a concrete on-slab foundation, no perimeter drains. Make it a small footprint. You're not going to have to clear the lot. You're not going to have to dredge. You're not going to have to fill. You're not going to have to reconfigure the wetlands. So looking at the evidence that we have shows that we feel like it's not going to create a negative impact on the other property owners. Certainly that's not what we want to try to minimize any impact to any abutting property owners.
I don't think that there's any debate on looking to minimize the impact on the property owners. And certainly, you made mention multiple times about a variety of different measures from, I think, rain gardens and permeable driveways, and it certainly made a lot of mention of preventable measures they're looking to put in place. So there's no denying that, and there's no denying that Ms. LaRusso has every right to do whatever she wants with her property. And obviously she's trying to accommodate the unique situation of this property. I guess what I'm hearing, and I could be wrong, but what I'm hearing from the abutters is that I think their concern, or one of their concerns, if this property is built, is what happens, you're right, based on the data you have, this is what we see. Well, what happens if you build it and it gets worse? And I think their concern is if it's built, it gets worse. I don't think any of them have there's nothing personal against Ms. LaRusso, but it's more of if it's built, what happens? Because water's got to go somewhere. So, are these people are people going to start having flooded basements? Are they going to start have erosion of foundations? I mean, so I think that's the concern, that at least what we're hearing from the abutters.
what happens if I build it and it actually improves? We don't know.
That's
do
true.
we?
That's true. And that's
We don't.
and that's the other side of it as well.
I
What-
have.
Yeah.
Yeah, I have talked to Normando Associates, who is an engineering firm out of Portsmouth. They have given me, in addition to the New Hampshire Do-It-Yourself manual, they have given me a quote for a permeable driveway for swales. They can actually calculate the runoff of rain from the size of the roof that I'm building and tell me how much rain can actually be collected, how much rain could actually be absorbed into the ground. They are an engineering firm with high credentials, and they said that it's actually a doable, project. They gave me a la carte list of items, and so one of the first things I'll do is a permeable driveway where they make these baskets that capture rain. One of the gentlemen who spoke said, "We don't know what she has planned," and I said, "This is my plan. This is what I will do. I don't know how to otherwise convince you. You have to have trust in that I'm not going to clear cut the property. I take, a personal interest in maintaining an ecosystem with all kinds of plants and flora and fauna. So
No, and it certainly have taken measures and had mentioned it, and certainly understand that, again, I guess, to Lynn's point, it's there's nothing that binds you to do it, but I'm not saying that you would or you wouldn't, because you're coming forth and saying
I
it.
wouldn't have gone this far with a plan
Exactly.
and then switch gears and do something else.
I'm kind of curious, just give me 1 second. I'm kind of curious if this does go through, does conservation have to be brought in on this because of it's so close to the wetlands?
No, because it is just a residential lot, there's no requirement for that.
Okay.
And I will also say that while the petitioner's made a lot of statements about what she plans to do, the board may not be able to condition that and have it actually carry through. If this were to ever get elevated to a court situation, that discussion would be captured in the minutes, and that would have some weight at that point, if it were to ever come to that point for whatever reason.
Okay.
So,
Lynn?
I have no doubt about your good intentions. I think what you're trying to do and what you hope to accomplish is admirable. I think it's probably one of the best things that could be done if you're going to build on this lot. But this is you, and that doesn't obligate anybody that if you decide you're gonna go someplace else and sell it, or if you're gonna pass away and the lot passes on, there's no control over somebody else's following intentions. So you're, well, no, there's a lot of things that you can't do that you're saying you're gonna do that you can't obligate a future owner to do.
Just like we can't obligate you to put in a permeable driveway, can't obligate you to put in all of the things that you are, and with all good intentions,
Yep.
you're looking to do. We can't obligate you to do that. At the end of the day, it's, we can, it was, so I was kind of have to see both sides of it, from that perspective.
And it's difficult because we're talking about water. We're
Right.
talking about a natural resource. It's not static, it changes over time, right? That's controlled by variables beyond what we can manipulate, or even the abutters for that matter. I mean, when you look at the subdivision and you look at the homes and how they've developed over time, there have been properties that have had additions built, renovations, porches, decks put on. Those additions, renovations may have contributed to some of these very issues. And those aren't issues, again, that are going to exist at a static point in time. They're going to change with the rain that we get in a certain year, with how, and wetlands move. They grow, they shrink. So I recognize it's difficult, but with this lot would just be a vacant lot unless the board will approve a variance to construct a house there. And the concern is that it is a buildable lot, it's designated in the residential area, and what we're proposing, we feel is the best for this lot.
Okay. Any other questions or comments from the board? Rich?
The only thing I have is, I'm kind of stuck on this, is something that Lynn brought up earlier, is that I don't see unnecessary hardship if the property was purchased knowing that this did not make it through the zoning board last time, and knowing that there are harsh conditions to this property, making it difficult to build on. And that's, and that's not to degrade in any way, what the plans are. I really like what's been presented. It's just, I don't see unnecessary hardship.
Based on?
I don't see unnecessary hardship based on Ms. LaRusso purchasing this property, knowing that it could not pass in the zoning board, and knowing that its conditions make it hard to build on. I don't think this was I don't think she went into this blind. That's all. And I don't think that there's anything wrong with that. I can't in good faith say, yes, I see the unnecessary hardship if I don't. That's all.
Any other questions? Kathleen? Rod? Comments from town? Lynn? Lenny?
Can I make a comment on
any
the
final
unnecessary
statements? Yes.
hardship issue?
Sure.
So when you evaluate whether there's an unnecessary hardship, rather than looking at the plight of the homeowner, you have to look at what are the unique special conditions or circumstances that are unique to the property. When Mrs. LaRusso bought the property, we recognized it was a vacant lot. It was advertised as a buildable lot. Looking at it, the level of due diligence that we did happened after she acquired the property. We did not start digging into the previous application, the grounds for its denial, reviewing the meeting minutes, reviewing their plan, seeing the inaccuracies in their plan, and really evaluating it until after that point.
Thank you. Any further questions or comments before I close the public hearing?
I have no argument with that. In fact, I believe that's exactly what you did do, is you came after the fact to come up with justification for doing this. The lot is legally a buildable lot. It's registered as a lot in the subdivision.
Yes.
Whether it's actually buildable, I have my doubts. When the subdivision was originally done, the conditions were different. As the subdivision got built, you added a lot of impervious surface, which contributed to the water problems. And as the houses got developed even further, it just contributed to it. So I'm not sure you could find a house or a place on that lot to put even a small house like this.
Well, and it's important to note, too, with regard to the subdivision, in 1974, actually, the zoning board approved, there were eight lots that had to get variances to build there, so we've included that in your material. And I understand, I mean, and her particular lot is smaller than some of those others, but the point is that with the land surveying that Meridian did, and looking at this and recognizing that the town recognizes as a buildable lot, and that with the plan that we're proposing, I mean, we do feel like we can do it without creating a nuisance or negative impact to the abutting owners.
It may be buildable, but you can't do it without infringing on setback rules.
Right, we can't, I mean,
Right, and that's my
to say
point.
we cannot do it in strict conformance
Right.
with the
Right.
ordinance, correct?
Any other comments or questions from the board? All right. I'm going to close the public hearing. So, prior to any motions made, because just a point of fact to remind, I'm just saying,
You just
point of
have to
fact to
complete a
reminder,
sentence here.
it's just that, yeah, I am, it's been a long day. Point of fact to remember, if a motion is not going to carry, The motion approval has to be made first. If that is denied, then a motion to deny is made. So, is there discussion on the board regarding this matter, regarding this process? Rod?
I just have a general question. If this was approved, are we just allowing them to advance to the next stage?
If-
Or are we approving that lot as buildable as a representative of Merrimack?
We're approving that lot to be, we're approving that they can move forward with, we're approving that they can build a house on that lot within the 23-foot setback as opposed to 40-foot, and then we would move on to the next variance.
There are more
Right.
variances.
Right, so with the assumption that we approved that, we would go on to our next steps.
Yes,
What other groups in Merrimack would go in?
none,
None.
none,
None. It's tonight.
none.
Right.
It's
It
just
doesn't go before planning, it doesn't move,
Right.
go over to planning.
So if they were advanced by us tonight,
That's it.
so nobody else would go in and check to see that their platform was gonna float?
No,
There's no enforcement after it's granted.
this is,
All right.
Well, building department is
Right.
gonna
Building-
have it
confirm
built.
that,
Yeah.
You're
that
right.
the,
Right,
that
so-
the pad is being built where they proposed.
Right.
But other than that, there's
Right,
nothing
but
else.
after that,
Will-
there's
Will the
no,
building board go in and see that that pad is gonna float or be solid?
They're gonna determine that it is put on the footprint that has been proposed, and that's all.
And they would allow it to float?
Building,
I
building
think that's-
standards, we don't get into that stuff. That's nothing to do
Well,
with
I
the
mean,
zoning board.
okay, my thought is the safety portion. We're allowing them to advance. Nobody else is gonna go and check to see if that,
Well, they
So they-
still have other variances that they're
Right.
applying for, that if
Right.
we allow,
Okay, all
if we
right.
grant this one, then they've got more that they're asking for, and any of them can,
So assuming that all
granted
of
or
the
denied.
dimensional relief applications that they're seeking tonight get granted, they would have to put forward a building permit application to the building department that would have to meet all applicable building codes and regulations. And they would be dealing with, strictly with the building department from that going forward.
thank you.
also, the staff recommendation does state that the granting of any variance or special exception is explicitly dependent on granting all of them. So if
Right.
one fails, they all automatically fail.
I understand that.
Okay.
Thank you.
any other questions, discussion? Can I have a motion, please?
I will make the first motion to,
grant.
Great.
oh, just switching up my paperwork here. To grant Lorraine A. LaRusso, applicant owner, variance under section 2.02.7.6 of the zoning ordinance to permit construction of a single-family dwelling 23 feet from a wetland, whereas 40 feet is required. The parcel is located at 12 Cary Drive in the R1 Residential and Aquifer Conservation Districts, tax map 5B, lot 176, case number 2018-30, with the staff recommendations that this be contingent on the other variance and special exception.
Do I have a second?
I'll second.
Seconded by Lynn. All in favor, say aye. Aye. All opposed?
Aye.
Raise your hand. Abstain? Okay, the motion does not move forward. I need a second motion, please.
Good.
Somebody?
Okay.
Kathleen, please. Oh, Kathleen, why don't you make the motion, please?
Deny, yeah.
And before we make a motion, we do need to discuss what we're going to be citing as grounds for the motion.
For
So,
denial of the motion? Yep.
the denial, the comment that I had made was regarding unnecessary hardship. I'm not sure if being contrary to the public interest is something that you want to notate, but my only comment was regarding unnecessary hardship.
Anything you want to add, Lynn?
Oh, just taking
Right,
notes.
see if you make
I
a
can't
note.
remember things
that's
from one
okay.
minute to the next. I think the board should deny the variance
under section 2.02.7.6 of the zoning ordinance to permit the construction of a single-family dwelling 23 feet from a wetland, whereas 40 feet is required. The parcel is located at 12 Cary Drive in the R1 Residential Aquifer Conservation Districts, Tax Map 5B, Lot 176, case number 2018-30. And this would be due to the petition is unable to prove the unnecessary hardship, and also that this could be contrary to the public good.
Is contrary.
Is contrary.
Do I have a second?
Is that all? We're just, in the motion right now, the language is that they could not prove unnecessary hardship. You're not saying why. And that
So-
they are not meeting the.
Rich, can you expound on
We need the full
unnecessary?
thing as part of the motion.
So based on testimony tonight, this property was acquired knowing that a vote was brought to the zoning board before, or a petition that failed. So this is not a hardship if it's a event that happened in the past that was known about.
And then the second one was, you said,
Contrary to public good.
so define that? Or if Lynn or somebody would like to define?
The potential effect on,
The potential effect on the water problems. in
on
the
surrounding
area.
problems.
On surrounding properties.
Rob, is that you sufficient? Do I have a second?
I'll second.
Lynn seconds. All in favor of denial of the petition, say aye.
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 All opposed? That's 4-1-0. At that moment, I guess, we'll be withdrawing the rest of the petitions for this evening.
Thank you, and we'll get a statement for the reason for the denial and citing the specific grounds for the unnecessary hardship.
So I've got that the unnecessary hardship was not established as the owner had bought the property knowing that a similar petition was denied in 2017 or previously. And the other portion was that it was denied because the petition is contrary to public interest in that due to the potential effect on abutting properties as a result of the water issue.
Drainage.
Thank you.
You're welcome. Thank you. With that being said, the petitions for special exception under 2.02.7.A.4 and the variance under section 3.02.4 of the zoning ordinance to permit installation of a septic system within 10 feet of the side property are at this point withdrawn. I don't think we need to do a vote on that, and that is that. Okay, so we're gonna take a 5-minute break since we've been here a little bit. If anybody needs to get up and stretch their legs, we'll continue in 5 minutes. The next item is from staff. I'll let Rob take this.
So, The board may remember a few months ago, it dealt with a case for a petitioner, Arnie LLC, that they sought a motion for rehearing. That rehearing was denied. They did appeal to Superior Court. The judgment was recently issued on that, and the Superior Court judge remanded the case back to the ZBA for failure to properly consider the hardship issue in that case. So they're going to be coming back in October. We are going to, or Town's legal counsel has requested to have a non-meeting with legal counsel ahead of time at 6 o'clock on Halloween, just to kind of go over everything, catch you all up to speed on everything that was involved from that whole decision and to what your role actually is when you actually see them for the public portion of the meeting at 7 o'clock. So I just wanted to let everybody know that you'll have to be here at 6 o'clock to meet with him. And
No costumes required, right?
no costumes required, no. He will also be available, that case will be first on the agenda, and he'll be available to sit and participate in the discussion as needed, answer questions as needed. Matt Surge.
Don't forget your mic. And that actually, and thank you very much, Rob. So that'll be 6 o'clock, and that'll be at the community development.
You could do it in here, we can just close the doors, or you can do it, we haven't really set that, but we can talk about that after we're.
Okay, so there'll be an email out on whether we're meeting here or community development. We'll work that out. But I did want to bring up something real important, and it's kind of a learning, because, you know, we have some new folks on the board, and just kind of, we actually, honestly, I sat before town council and looked through our last year, and we didn't really have a lot of denials. We generally approve, but when we go through a denial, if there's going to be a denial, we have to go through the approval first, like we did, and then denial. This case, and as well as this case we heard this evening, it's very important, if something's going to be denied, that we have a very thorough reasoning based on the 5 points of law. Why? So it's unnecessary hardship, that's fine. Why? Substantial justice, whatever it is. If it doesn't meet that, that's fine. Why doesn't it meet that? And that has to be an agreement upon the board. So if you're going to if you're going to deny, make sure that you have that, because in a case like this, Arnie, as well as this, and then I've been on the board for about 10 years, and I've seen a couple of things come back where we didn't necessarily outline the specifics to that. So it's all learning.
Now this one's coming back.
Well, it's all learning, but it's something that definitely keep in mind. If when we in a situation in which we have to deny a variance or a petition in that sense. Okay, that being said, we have approval of the minutes for August 29th.
Move we approve as printed? Move we approve as printed?
Do I have a second? Okay, motion made by Lynn, second by Kathleen. All in favor? Aye. That's 4. All opposed? Abstain? One abstention, so 4-0-1.
Not to backtrack on discussions, but
Oh, sorry. Should've.
so on the next zoning board meeting, I will be taking my small children trick-or-treating. I apologize.
So you will not be here?
I will not be here.
Okay.
If I do, I might be in a T-Rex outfit. I have one.
I would be willing, you can show up in a T-Rex outfit for the, I think you should.
Don't take this any further.
I'm smiling.
Move we adjourn.
I'm smiling.
All right, it's kind of your motion to adjourn?
Yep.
Second? All right, motion adjourned by Kathleen, second by Rod. All in favor? Aye. Thank you very much. Have a great evening, folks.